It's my pleasure to introduce our speaker today for creation and management of endowments, the legal side. This is going to be way more exciting than you think. Candace is a terrific speaker. I've worked with her for a number of years. She's with Ballard Spahr, which is a major firm, over 600 attorneys in 15 different locations across the country. Candace is an attorney that works in the not-for-profit space. She's the team leader, in fact, of Ballard Spahr's exempt organization team. And I guess one of her bio says one of the leading nonprofit attorneys in the Southwest, but I would argue one of the leading not-for-profit attorneys in the country. She serves clients all across the country from coast to coast. Does a lot of work with a wide variety of organizations, including universities, healthcare organizations, religious organizations, private foundations, the whole gamut. She and I have served clients jointly and separately for a number of years. I can attest to her knowledge in the area. She is perennially listed in as the best lawyers in America, particularly in the not-for-profit area, and has multiple awards in that regard. She's a member of the tax law section on exempt organizations with the American Bar Association and a fellow with the American College of Trust and Estate Council in the not-for-profit category. So highly regarded across the country. I'm happy to introduce to you my good friend, Candace Michaud.
Thank you, Brenda. So today, let's talk about creation and management of endowments. A scintillating topic. So we're going to talk about a few of the legal principles, and then I understand that you're going to have some accounting principles for endowments in a few weeks. So let's talk about what an endowment is. And it's interesting when you get some different perspectives, because most donors, board members, and nonprofit fundraisers will say, well, it's a fund where only the quote, income is expended and the principal is going to be preserved into perpetuity. When you talk to a lawyer, we're going to tell you it's an institutional fund, not wholly expendable on a current basis under the terms of a gift instrument. And then when you talk to your accountant who's preparing your 990 when you're a nonprofit, they're going to be asking you about things that are permanently restricted, temporarily restricted, and what's board restricted. So you're going to get very different perspectives depending upon the person that you're asking about an endowment. So let's talk about a little bit about what the law says. So some of you may have heard the acronym UPMIFA. Well, UPMIFA stands for the Uniform Prudent Management of Institutional Funds Act, and it applies to decisions made about funds that were created before the date it was enacted in a state and funds created after the date of enactment. And it replaced what was called UMIFA, which was the Uniform Management of Institutional Funds Act. You'll notice there's just this prudent that's been inserted into it. And this law has been in existence now for probably, 15 or so years. And it really kind of swept the country after the Uniform Laws Committee, which is a body of lawyers that gets together from across the country and basically come up with what they think would be a good representative law to be adopted in the states across the country to give some uniformity to practices across the country. And UMIFA was having some shortcomings that were being seen, especially in the .com bust era, and you had a lot of underwater endowments. So UPMIFA came in. And you may never have heard it called that. In some states, like in Arizona where I practice, we didn't call it UMIFA or UPMIFA. We called it something else, but it is we adopted a very standard version of both. We now have UPMIFA. And now basically all jurisdictions have it, and we always say except Pennsylvania, but they have a version of what looks somewhat similar for their endowments and institutional funds. So when you look at definitions there, an endowment fund is an institutional fund, which is also a defined term, that under the gift instrument is not wholly expendable by the charity on a current basis. A gift instrument is a record, which is some kind of a document or information stored in an electronic medium even, such that it can be perceived, under which property is granted to, transferred to, or held by an institution as an institutional fund. So an institution, for our purposes today, it can be a university, a 501c3, it can be any kind of organization like that, where you receive a gift of funds. Note that even your solicitation materials can be a gift instrument. So when you go out and say something like, make a donation to support our music program, all proceeds will be kept permanently with only a yearly stipend used for the fund, from the fund to support our music program. Or our endowment will be used to support scholarships for teachers. These examples not only create endowments, but they're also endowments restricted to noted purposes. So the first example is an endowment for the music program. And the second is an endowment for teacher scholarships. So when you go out and solicit funds for a specific purpose, you're restricting those purposes when a donor gives in response to your solicitations. So if you're accepting funds based on a specific solicitation, you should be sure to keep a copy of that solicitation because you've restricted those funds. So you should know that UPMIFA, whatever version your state has adopted, is the default rule. So if I say, here's $1 million, keep the principal, spend the income, that is the default rule, drops into these statutory provisions, and it can only be altered by a very clearly drafted gift instrument. So if I say, here's $1 million, spend the income, that's not exactly what's going to happen under the rules. And so we're going to talk about that. Although I, as the donor, think that's what's going to happen. The default rule is a little different. And as a preview, the default rule is going to let you follow whatever spending policy you have in place, which most times now spending policy lets you spend 4% or 5% of the whole fund, not just of the quote principal. So you want to think about when you develop an endowment fund or some kind of a fund like that, having a spending policy in place so that you can fall under UPMIFA and use your spending policy as the default. Under UPMIFA, the board may appropriate for expenditures so much of an endowment fund as the board determines is prudent. That's the standard now. This allows appropriate levels of expenditure when there's downturns or when there's periods of great returns. What was happening during the dot-com bust was there were endowments that had very strict only spend the income, which used to be the rule, and you had a baseline and you couldn't spend below that. So organizations had endowments that were throwing off income, and the question became, are we allowed to spend the income even though the value of the endowment has dropped below what was, the phrase was below the historic dollar value. So here's $1 million, spend the income, but now the $1 million that was invested has dropped to say 750. Were you allowed to spend the income? And there was a split developing in the circuits. So that was much of the impetus for the MIFA rules. So if you want to limit the authority of a board to either accumulate or appropriate expenditures, you actually have to write around what is the default rule of spending what is prudent, and would be writing around the expenditure policy. So it's actually pretty difficult for a donor, if they don't know about this rule, to write around it very specifically. A lot of organizations have put spending policies into place for their endowment, and they say we have the ABC endowment subject to our spending policy. And then if you go out and look at the spending policy is, and it's going to be longer than this, but the spending policy will say something such as, you know, based on the rolling quarterly average of, you know, 3 years, the fair market value, the organization may spend up to 4% or 5% of the endowment fund. And it isn't limited to just income, because that also pushes the organization into a situation where is it investing for income, or is it investing for growth of the whole fund or the principal? So that was another thing that was happening under the old law. So now the question is, what's prudent to spend? Decisions have to be made in good faith, with care of an ordinarily prudent person in a like position under similar circumstances, with consideration of various factors such as the duration and preservation of the endowment. Is it a perpetual endowment? Is it an endowment for a term of years? So is it a 20-year endowment, a 10-year endowment? What's the purpose of the institution and the endowment fund? Is the institution an orchestra? Is it a university? Are you giving scholarships? Is it a school? You know, what is the purpose of the organization, and what was the endowment established for? General economic conditions. Are we in a time of increasing returns or decreasing returns? Are we about to enter a period of inflation or deflation? Expected total return of income and appreciation, and what are the other resources of the organization? So you're supposed to look at all of these factors when you're deciding where to set your return and, your withdrawal amount. So a lot of times the spending policy will say up to a certain amount of funding every year, and not require that that full amount of funding be taken out of the endowment every year. And that way you can look at all these funds and these factors, and your spending policy will require that you look at all of these factors. You should be aware that some states have adopted a rule that if you withdraw more than 7% from an endowment fund, that has created, in any 1 year, that has created a rebuttable presumption of imprudence. Now, this was an option in the uniform law. Not every state has adopted this provision, but a question would be, even if your state didn't adopt that, does that raise a presumptive question as to whether or not spending 7% is imprudent? By that same token, just because your state didn't adopt it, does it mean that whatever you did take out is prudent? And I'd submit no, because you still have to look at all those factors. So you want to always take a look at the factors when you're deciding what to take. And this presumption does not come into play if the gift instrument says you are to take 10% every year, because that's a specific directive from the gift instrument. And maybe they want that endowment drawn down more quickly. So you always have to look at the gift instrument because it may direct something other than your standard spending policy or what you might otherwise determine as a board would be prudent. The donor's intent is always going to trump other things. So when you're looking as a board member and as an officer at investing and managing endowments, not only are you subject to your standard duties of care when you're serving as a board member and an officer, and those are going to be codified in your statutes usually, and they are certainly going to be in state law through case law. But MIFA also codifies in these separate sections additional duties. So you want to be mindful that you now have very specific duties that are imposed for the investment and management of endowments and institutional funds. So let's talk about those. You have the duty of loyalty, which you have as a director and officer. And the standards are slightly different for nonprofit corporations as opposed to charitable trusts. So for a nonprofit corporate director, you have to act in the best interest of the corporation. And as trustees, you have to act in the sole interests of the trust. You have the duty to act in the best interests of the charity, and its interests are before those of others. So that's what you always want to think of when you have a duty of loyalty. Your loyalty is to the charity or to the trust. And that, by the way, it's the duty of loyalty where we see the conflicts of interest come up. You also have standards of care for managing and investing that are written into law. So you have to act in good faith with the care of an ordinarily prudent person in a like position under similar circumstances, which is the duty of care. You also have the duty to act as a prudent investor, reasonable care, skill, and caution. Take a portfolio approach to looking at the investments. You have to act in good faith. You have to act with prudence under the circumstances and prevailing at the time of the decision. I think that slide was a duplicate. I'm sorry. The other thing you need to note is you have a higher standard of care if you are a director who is specifically selected because you have a particular expertise or some kind of experience in investment management. When you are looking at expenses, there is a specific duty to incur only appropriate and reasonable expenses. That's also written into the law, into the MIFA statutes. So in addition to care, loyalty, and good faith, you have a specific duty to watch the expenses. So you have to look at the cost to invest and manage. That's going to require that you consider the size of the assets, the purposes of the institution, the skills and sophistication of the investment committee. When you're selecting investment managers, you're going to want to look at the costs, their duplicate fees, et cetera. So when you look at third-party investment managers, there are specific provisions about delegation of management expenses. And you should only choose an investment manager, after thorough due diligence of the investment methodologies and the fees, you're going to want to look to limit how the investment manager operates, and you have to periodically review the manager's work to ensure that they're complying with the proper guidelines. So normally, your organization is going to put an investment policy statement into place. You're going to adopt one, and you're going to want to ensure that it's being followed. Many of the organizations with which I work have investment policy statements that have ranges for their bond funds and equity funds, and they have policies about whether or not they invest in some of the alternative investments. And they periodically look at their portfolios and see if the mixes that they've defined are being followed. And they have worked on those with investment advisors who are fiduciaries to them so that they get the mixes right. They review them. Sometimes they may adjust those. They always make sure that they're within the investment policy statements. And they don't have different investment policy statements for different investment advisors. They have one investment policy statement, and a lot of times they may have their assets split between two investment advisors, and their investment advisors are following the same investment policy statements. Looking at the costs and the fees, again, in compliance with the other duty that we talked about. They're picking their investment managers based on their competence, their compensation. Are there any conflicts with board members? Do any of the board members work for the investment manager? The investment manager should be chosen based on competence, compensation, experience, expertise, not based on friendships. You need a written agreement in place, and you are not going to be liable for losses. You're not a guarantor of what all the investments are going to do, so long as you have made the selection with an independent review and complied with your duties of care, duty of loyalty, and acted in good faith. So you want to be sure that you are documenting that you've gone through all of these steps. These things are going to be important. If you have an investment committee, you can delegate some of the RFP work and searching for the investment advisor to that committee and have them do a lot of the legwork and then come back with a recommendation, because not every board member is going to have this expertise. So you also have a duty to diversify unless, due to special circumstances, you have some assets that you don't want to, or for whatever reason, shouldn't be selling. So this might be some specific pieces of artwork that are displayed. And while those aren't, quote, investments, you may have a lot of pieces of art that make up a specific collection that was donated to you. You don't want to go out and diversify those, and maybe that's the bulk of your assets. So you want to take a look at some of the assets you have and the decision to diversify. There are some states that have adopted a provision that says if you've got certain assets and you've chosen not to diversify them, you need to look at those at least once a year. Sometimes you have a significant portion of stock and you can't divest yourself of all of that at once. Brenda, do you have something you want to add?
Two questions. So on the diversification one, if we have a program specific investment, so it's an investment, we hope to make our money back, but it's very driven to our program or our mission, does that make it difficult to diversify if that's significant, or is that a justifiable reason not to diversify? What
I'd say that's a justifiable reason not to diversify, because usually a program related investment is something that you're going to hang on to because it's related to the programs that you're operating.
Okay. Then we also had a question about, this is back on the expenditure policy. So if you have a policy to expend 7% or 5% or whatever your policy is, does that include losses that you recognize in the portfolio? So fluctuation in the market? Or is it just to distributions of funds out of the endowment?
So normally when you calculate the fair market value of a fund, it's over, a lot of organizations will do it over 12 quarters, and it takes into account the value of the fund. So that's going to take into account losses and gains and everything. And you do it that way so that you don't have these massive fluctuations. So there's usually a formula to take into account all of that. And so it's not just a quarter by quarter or annual by annual calculation. And it will, I think I mentioned, it will normally say something like you run that calculation over the 12 quarters and it will say, and you can take up to 5%. So if you look at that and that value is maybe perhaps lower than you thought it was going to be because you've had running losses, then you're free to say, well, we've had a lot of losses over the last 12 quarters. Maybe we'll take only 4% and leave funds in there to grow. Or maybe we need to look at our investment manager.
So imagine you have a 5% spend policy and you've done a rolling average over 12 months and you figured out, what that 5% would be. But in the current period, whether it's the quarter or the year, the stock market just dropped and you had either realized or unrealized losses of, say, 10% of your portfolio. Does that mean you have overreached your spend policy because of those losses? Or can you still spend 5% of whatever's left and still be deemed to be prudent and within your expenditure policy? Does losses count as an expenditure?
So normally you would still be able to spend and under the rules, but if you look at that, you might want to take a look and say, is it prudent for me to do that? Even though I had already, remember what you're doing is appropriating it to spend at a certain point in time. So if you had already appropriated that, you might look back and say, we haven't expended all of it. And so we might want to not take some of it. So you're appropriating it as of a certain point in time to spend it. Okay. So I would say if you appropriate it and then you have this massive loss, you might say, maybe we don't want to spend all of it now. Or, it's the stock market and maybe we'll make it back shortly.
Okay, so what I'm hearing is if I have gains in my portfolio, that doesn't necessarily mean I can add it to my 5%. And if I have losses, that I don't subtract it from my 5%.
Oh,
but I
correct.
Still have to overall look at.
Correct. Now I understand your question better. Yeah. Yes, correct.
I still have to look at what's prudent based on overall trends. A momentary drop in the portfolio doesn't matter, but if it's a significant, we might choose not to max out on our expenditure policy.
Correct.
Okay.
Yes.
Thanks. Those get us caught up to the questions.
Okay, so we're talking about diversification. So the comment was that you normally want to look at diversification at least annually. Maybe depending on the asset, you might want to look more frequently. You might want to think about, it might be some kind of specialized asset. Do you need to look at that? So when you're looking at investments, the organization should consider, and you're going to take, these are going to look a lot like the rules about whether you should diversify and whether you should hold assets or invest. General economic conditions, again, effects of inflation and deflation, tax consequences. Are you going to be generating unrelated business income tax by the investment that you're going to make? The role of each investment in the overall portfolio. Are you balancing the portfolio? So do you have a small amount of what we call these alternative investments that tend to be maybe a little more risky, but they might throw off a bigger return? The expected total return from income and appreciation, other resources, your need to make distributions and preserve capital. So you want to look at all these factors when you're looking at the different investments that you're making. You also want to look at the total portfolio when you're looking at risk and reward. And that's what I mentioned about these alternative investments, right? You might have a few of those and then balance it out on the other end with some very, safe investments, whatever those are going to be. You also want to take a look at, do we have property that really isn't consistent with where we want to be, or because we have some individuals on our board that are really versed in certain kinds of investments that may make it appropriate for us. So it's one of these, look at all the factors, identify, do your due diligence, and document what you're doing. Document. So let's talk about, you've received a gift instrument and you now have a fund that's restricted, or some property that's somehow restricted, and you want to try to either release or modify those restrictions. This happens pretty regularly. There's lots of case law on it. And how can you somehow modify that, either because you've cured the disease that it was intended to cover, or it's been around for such a long time that it's sort of an antiquated restriction. There was a case years ago where a church was given a piece of property next door to it so it could cut the timber off of it to use it for heating. Well, the church had different methods of heating now, didn't need the wood burning stove. So you can always go back to the donor and get a release or a modification of the initial restriction. If the donor is still alive and they're willing to give it to you, that's a great option, because then you don't have to give notice to the courts or the Attorney General, or go through any of this other rigmarole that we're going to talk about. So the easiest way to modify a restriction or get a restriction released entirely is to go back to the donor and just say, hey, we don't need the timber from that lot anymore. Do you mind if we sell the lot and use the proceeds to put in central air and central heat, or build an extension we've grown so much, any of those things. So you have to be able to get it from the original donor, though. You can't get it from their executor or from their kids, because often these cases come up when it's the kids saying, or the grandkids saying, grandpa gave you that lot so you could cut the timber, and you're not using the timber anymore, so now we want the lot back because it's really valuable. And they'll take you to court because you're not using it the right way. So MIFA allows the charity to get it released if all you have to do is go and get the donor permission. Another way to go and get it is through what we call the Cypre doctrine. And I'm going to talk to you about two doctrines that sound very familiar. And when you read cases about them, or you look at the courts in your state, you're going to say, these sound a lot alike, because a lot of times the courts will talk about them at the same time and then just pick one and go with it. And the underlying theme is always trying to get as close to donor intent as possible. So Cypre is applicable when the courts try to find a modification as near to charitable intent as possible, and the original purpose has become unlawful, impracticable, impossible to achieve, or wasteful. And then the modification is going to be consistent with the original purpose. So you have to, under the MIFA statutes, you have to give notice to the Attorney General and file a court action. So you're basically going to court as the charity saying, look, we have this fund or this piece of property or something that's restricted to this certain use that the donor gave us, and we really need to modify it because the purpose is either now it's unlawful, or it's impracticable, or it's impossible to achieve, or it's actually wasteful. So could you modify it to this? And you always, again, want to keep in mind, it's got to be as close to the donor intent as possible. The doctrine that is very closely related to that is equitable deviation. Now, this one is supposed to be related to an administrative or procedural restriction that was imposed by the donor. But as I said, as you read cases, what you're going to find is the courts kind of conflate the two. So it's regarding management or investment of a fund. And what, again, you'll see that it's the restriction is either impracticable or wasteful, or it impairs the management or investment of the fund. And it's because circumstances weren't anticipated by the donor. But if you think about that, that's also true of Cypre, right? They didn't know the disease was going to be cured, or electric heat was going to be invented, something like that. And again, you have to give notice to the Attorney General, and you have to go to a court action, and you're trying to stay as close to what the donor wanted as possible. And often what happens, again, in both of these is an heir will come in and say, that's not good enough, we want the property back. There's another one that's small old funds, and states are a little different on how you get these, but it's basically the fund is old, and states vary on the number of years, but it's going to be 20 years old, 10 years old. Again, states vary. And it's going to have $25,000 to $100,000 in it. And you're basically saying, look, it's been around forever. It's the fund, the restriction is impracticable or wasteful. The restriction impairs the management or investment. And we just can't do anything with this money. You have to give notice to the Attorney General. There's no court action required. And you're saying, we're going to erase the restrictions to this, and we're going to use it for this purpose. That's close to the donor intent as we can get, but we can't use it what they wanted because of these reasons in the middle. So you can see that it's sort of a combination of Cypre, equitable deviation, and you have to give notice to the Attorney General, and you're deciding what to do with the fund, trying again to stay close to donor intent. So those are the ways you can modify or release restrictions under UPMIFA. And again, your state is going to vary on 20 years old, 10 years old, 25 years old, and then how much money is in the fund for you to even be able to try this one. So who has standing in these cases? And standing is a court doctrine that says I have the ability to go to court to try to enforce the restrictions that were put on there. At common law, which is without a statute, there were only a few people that had standing.
Well, Candace,
Yes.
we have a question. Back to the cypres or the equitable deviation, there's a question that says, okay, we have to notify the attorney general. Who else gets notified of the court action? You get an attorney and they file something at the court. Do you have to tell the donor or the donor's family, or who else?
It's gonna depend on the way the particular statute's written. They all require that you notify the attorney general. And a lot of times the attorney general is going to notify the family, but many times the family is already well aware of what's going on. And, you know, there's been various cases like the church land I brought up. There's been another where there was a garden plot that was in the middle of the city and the heirs were already well aware of that because the lot was very valuable, right? So it's going to depend on who else has to get notice or if the attorney general chooses to get notice. But the statutes are usually pretty clear about who has to get notice.
Okay, so there may be other people involved.
Yes.
All right.
Frequently, there's other people involved.
We did have one other question while we've got this little break in the action. Someone wants to know if the rules are different between private foundations and public charities.
Not when MIFA applies. So if you have an endowment and institutional funds, these are applicable to you if you're trying to get restrictions removed.
But it's my money. It's my private foundation.
It's not your money, Brenda. I'm so sorry to tell you that. Because you gave it away to another legal person, a private foundation. So it isn't your money.
So it still belongs to the public in a sense, even though it's called a private foundation?
It does. So
bummer.
sorry, Brenda.
I'm going to have to think about that.
Once you give it away, it's gone. Any other question you want to ask Brenda about your money?
Oh, that's all I had for the moment. I'm going to have to nurse my wounds about that. But I think it is important to think it is a private foundation. It's closely held. The money is, it's much easier to get the donor's consent to change the restriction if there was one put on it to begin with, because they're probably sitting on the board. But some private foundations are multi-generational, and once that original donor passes away, what I heard is even though the kids are on the board, they can't just willy-nilly change it. They have to jump through some hoops.
Well, we would say yes, that's true. In a private foundation, a lot of times the kids are sitting on the board and they have control of the bylaws and the spending. And many times, although they're supposed to go get the restrictions changed the way we talked about, I've seen cases where that's not always how it's done.
So if it came to the attention of the Attorney General, I don't know who would complain in that situation, but the Attorney General would still have the right to say, you shouldn't have done that.
Yes, in many states, yes. So there's one other question that you may want to give a very quick answer to, because there is an accounting panel that's going to be later. But the question is, in what circumstances is there, it says non-related business income, but unrelated business income?
Sure. And yeah, that's totally outside the scope of just an endowment, but it depends what the endowment is invested in. So if you've got, if you're investing using margin, so you're borrowing money to make your investments, if you're leveraging your investments, if you're invested in alternative investments like partnerships or S corporation stock, any of those could generate unrelated business income.
And for private foundations, there's other ways to do that. So there's a lot of ways to generate unrelated business income. So
yeah,
there's one more question that we'll answer quickly, which is the spending policy. Would you put the spending policy in the investment policy statement or have a separate document? I always want a separate document because it's going to be tied to your endowment. And especially for a public charity, I want my endowment documents where people can see them, right? So they know what we're doing, and my endowment says subject to the spending policy. So I want people to know what my plan is. So I like to have the spending policy separate from the endowment. So I have no idea why the other items are not populating, but let me just tell you, at common law, only the Attorney General had standing acting on behalf of the public or the charitable class to challenge and enforce donor intent. Even the donor didn't have standing unless there was some kind of a reversionary right. Recent trends are that courts are allowing donors to sue based on breach of contract theory and those kinds of things. And the Attorney General often has limited resources and doesn't want to enforce these. Many times now, donors in their gift instrument are putting provisions that give them standing. And then what we're also seeing is that donors are putting what we call gift over provisions in their documents that basically say, if you don't do what I say or use this gift the way I'm telling you, then ABC Charity gets it. So now ABC Charity has incentive to watch you. And if you're not using the millions of dollars the way they should be used, then they will sue you and get the money from you. So there's lots of ways that other people can get standing now, other people or other organizations. So that's what we're seeing for groups that are trying to get standing. So let's do a couple of quick examples here where lots of money was left to endow and build things, and it was difficult. So a really great example was Salvation Army. In 2003, Joan Kroc was the founder of McDonald's, bequeathed $1.7 billion to Salvation Army. And the funds were restricted for these amazing community centers throughout the country. And they were half for construction and half for endowment. And then the local community had to raise the other half for the construction and half for the endowments. And it was a really big difference from how the Salvation Army had worked up until then. So she passed away, and then there was, the crash in the mid 2000s, and a lot of the community centers had to be canceled because they couldn't raise the money for the construction and the operational costs. So it took years and years to build even a handful of these. But if you also think about the way Salvation Army works, they aren't these lavish, decked out community centers, which is what she required in the endowment and the construction and everything that she put into the restrictions for these centers. So it was really unfortunate the way she restricted all of that money and didn't leave a lot of wiggle room in there. So it was very unfortunate because the donor restricted everything in a way that really couldn't be used by the organization she was trying to help. So it took many, many, many years to work all that out. So another situation was Robertson versus Princeton. And this is a situation where they donated $35 million in 1961 to what's called a supporting organization, which is a particular type of 501c3. And they created a school of public affairs. And then the board voted to engage professional management because now the fund was $550 million. And a member of the committee filed suit because they were allegedly using the money for all kinds of different things. And eventually the parties settled, but it was tens of millions of dollars in legal fees. And they eventually established a new foundation to carry out the original purposes. And what was happening was the center was straying from all the original purposes, a bit of the conversation Brenda and I just had. And really what happened was the gift instruments and the foundation that was formed to hold all the funds, the documents, apparently it was determined they weren't as clear as they could have been, who had control over the assets, how the funds were supposed to be spent. And so, you know, with tens of millions of dollars spent, and this was only, you see the amount here, the 40 million, that was only the amount that was reimbursed to the Robertsons. Princeton spent millions of dollars as well. So when you look at this, the clarity of gift instruments is super important as you're going through this. And there are lots and lots of cases where things like this have happened. Did you have something you wanted to talk about?
Well, before we kind of move off of that question, we did have some other questions.
Okay.
Someone wanted to know if the foundation has a lot of smaller, older funds with the same restriction, could they be consolidated?
That sounds like an accounting question, Brenda.
Well, from an accounting standpoint, we certainly could if they really do have the same, the exact same restriction. I don't know if there's any legal considerations of someone coming back and saying, well, what about grandma's money? And you're like, I don't know, we consolidated all that kind of stuff together. We no longer know how much is grandma's money.
So a lot of times we tell people that if they have the same restriction, you can consolidate it. And you certainly can consolidate them for investment purposes. A lot of times, if you're concerned about a donor wanting to know how you're spending the money and donor relations, you can consolidate them for investment purposes and then just keep the records of them for donor relations purposes.
Okay. So there's a specific question. If our organization decided to establish a bank account other than the community foundations to serve as an endowment fund, does our spending policy need to be like the community foundations, or can we put a clause in the policy that we can use the funds for a special project in the future or something? And I'm pretty sure that question really needs a little bit more back development to find out what they're talking about exactly. But I do have a client who has they had some permanently restricted contributions that they put with the community foundation, but then they did want to have some other permanently restricted contributions in a a brokerage account that they could control. And does it have to be one expenditure policy that covers both, or can you have two separate expenditure policies, one for each?
I think you can have multiple expenditure policies. I have clients that do that. They set up, so I have an example where I have a client that has several endowments. One is an endowment for scholarships, one's an endowment for a general endowment, and then one is an endowment for something else. And their expenditure policies are different. And they've said, you know, by way of example, maybe the scholarships are, we're not going to spend any money out of their expenditure policy says we're not going to spend any money out of this endowment until we reach X dollars. And then we're going to give grants of whatever the percentage is. And if that fund gets depleted over time, you know, their goal is to give a meaningful grant to students to make it count, right? But the other endowment, they've limited to just a standard expenditure policy. There's enough in there that they want to give, I think now, I don't know if it's 4.5% every year. So they have different expenditure policies. And when you read their blurb about the endowments, the different endowments, it says subject to the so-and-so scholarship spending policy. So the spending policies are named so that, and when someone makes a donation, they can request to click here and get a copy of this expenditure policy.
Okay, thank you. But we had someone ask about steps needed taken to change the name of an endowment. And I would think there's pretty much no steps that you need to take unless the name of the endowment is defined in a donor agreement. Am I missing something?
No, that's what I would say as well. So unless, you know, unless I gave the first 5 million and you named it after me because of that gift, right? Or that was part of my agreement, then I think you have to leave it there. But if you just called it the ABC Charity Endowment Fund and I gave, then I would think later you could change the name and maybe say for a while formerly known as the ABC Endowment Fund.
Yeah. Yeah, I don't know if there would be any, I'm always worried about unknown being named in someone's will and not know it. And if the will is written in such, give it to the ABC Endowment Fund, and you've now changed the name, if that's going to create a legal nightmare, or if you can show a history that, yeah, that's the same fund, if you're okay.
And I always like to, at least for a period of time, to be able to say formerly known as, right? Even if it's a footnote somewhere, because you certainly do that with organizations that have merged or something like that.
Okay. And then I think we're out of time. And thank you, Candace. Great job.
Of course.
Yes,
Thanks.
great job, guys.
Bye-bye.